The case was originally brought by Pamela Gaos and a couple of other named plaintiffs. They objected to Google's business model when it comes to internet searches. They filed the claim on behalf of themselves and 129 million Americans, about 40% of the American public. There was a second motion to dismiss pending when Gaos and Google came up with the current settlement that is the subject of the dispute. That settlement was approved over the objections of Ted Frank and Melissa Holyoke. Frank and Holyoke objected to the settlement agreement because the settlement agreement gives no money to the individual victims of the case who were allegedly hurt by Google's actions. The settlement in this case awards $8.5 million. Apart from 25% that goes to attorney's fees, the rest will go to a group of charitable organizations that have all promised to promote internet privacy. The recipients of the Spokeo Awards have ties to both plaintiff's counsel and Google, the defendant. Spokeo Awards started out as a way of redirecting funds that were originally granted to a purpose that is no longer possible. Could be that it's illegal, could be that the subject of the grant is no longer available. Rather than send the money back, the court can invoke CPRE in order to designate the money for a similar purpose. Class actions don't often involve CPRE awards, but they have become more common in recent years. The reason is because class actions often reach a point where all of the known victims have been compensated and there's still money left over. Rather than send the money back to the defendant, courts can invoke the CPRE doctrine to allocate the funds for a purpose similar to that which the class action was intended to receive. There are two primary concerns that arise from that. The first is a due process concern, that you are taking the money that technically belongs to the victims, to Google's victims in this case, and you are giving it to a third party without meaningful consent of the victims. In other words, their money is going to a third party and they really didn't have a choice in the matter. That's the due process concern. The second concern is a First Amendment concern, that by requiring the individual victims to give their claims or the value of their claims to a third party, you are forcing them to speak in the voice of that charitable organization who has its own goals. They may be laudable goals, but they may also not be the goals of the individual victims. And by forcing those individual victims to give their money to the charities, you are in fact forcing them to speak in violation of the First Amendment. The best argument for Frank is that Spokeo-only settlements are a collusion between the defendants and the plaintiff's lawyers to enrich themselves at the expense of the class. By disposing of plaintiff's legal claims without providing the victims any actual compensation, then the defendant and the plaintiff's lawyers and the courts by association are depriving those individual plaintiffs of their due process rights. The best argument for Gaos in this case is that these type of settlements are necessary to remediate important societal harms and promote important societal goals, and that this is a voluntary settlement between plaintiffs and defendants, and that individual objections by one or two out of 129 million should not be allowed to derail an important settlement of this type. One side of the case says that individual victims deserve better protection than this. The other side of the case says that these types of settlements are an important tool for promoting social welfare, and that social welfare is a legitimate aim of class action litigation.